All right. Hi, everyone. Welcome to the Sharmin Bijan Mossavar-Rahmani Center for Iran and Persian Gulf Studies seminar series. I am Maral, a postdoc at the center. I would like to first bring to your attention that we are going to have a very exciting concert coming up at the end of this month. On Monday, November 25th at 5:30 p.m. in the Frisch Center on campus, we will host Euphoric Whispers, featuring Ali Akbar Moradi and Pejman Haddadi, two of Iran's most renowned musicians. Moradi is the greatest living master of the tambour, which is a string instrument, and Haddadi is a percussionist who plays a tombak and daf, and who is also has been a member of the Dastan ensemble for over 20 years and has collaborated with countless master musicians in Persian and world traditions. They will perform ecstatic and trance-inducing Kurdish music from Western Iran. Please do make sure to register for this event ahead of time so that you can guarantee yourself a ticket at our website, iran.princeton.edu. This event is free and open to everyone. You are welcome to bring everyone you know on and off campus to this event. So I want to, again, make sure you put that in your calendars, November 25th at 5:30. Now, I am delighted to introduce our esteemed speaker for today's talk, Unveiling Discursive Spaces, Modern Shi'i Legal Debates on Homosexuality in Islam. Professor Mehrdad Alipour is Veni Research Fellow in the Department of Philosophy and Religious Studies at Utrecht University. His work examines the transformation of Islamic body politics concerning gender, sex, and sexuality across pre-modern and modern eras. After graduating from the seminary of Qom in Iran, Professor Alipour earned his PhD in Arab and Islamic Studies from the University of Exeter in the UK. His forthcoming monograph, Islamic Body Politics, Non-Binary Intersex in Shi'i Legal Tradition, 1400 to 1919, stems from a project entitled Beyond Binaries, Intersex in Islamic Legal Tradition. Professor Alipour's other book, Negotiating Homosexuality in Islam, a legal hermeneutical examination of modern Shi'i discourse, published with Brill this year, is the first academic exploration of the discursive spaces for debating homosexuality within the Shi'i legal context. A couple of his recent publications include Homosexuality and the Prospect of Before Revolution and The Nexus Between Gender-Confirming Surgery and Illness, Legal Hermeneutical Examinations of 4 Islamic Fatwas, which you can find in the Journal for Middle East Women's Studies. Please join me in welcoming Professor Mehrdad Alipour.
I didn't try this one. I couldn't use this one. It doesn't work. Sorry. Anyway, thank you, Maral, for your generous introduction, and thank you all for being here in such a beautiful day. It's a special thanks. I would myself rather go out for a walk. And your beautiful campus, yeah. I would like also to thank Behruz for inviting me, and a special thanks to Alison for making everything run smoothly. So, yeah. Which one is that? Is this one, I think. I think I turned it off. Okay. Yeah, you solved it, but you didn't tell me how to use it. I'm supposed to talk about my current book published by Brill in its series. Yeah, this is, okay, great. Yeah, this book, as you can see, in its series on Islamic law and society. And unfortunately, we don't have time to discuss the entire book, so I encourage you to read it yourself if you haven't already. And I hope this discussion will assist you in navigating the text if you're going to read it. Before I start, I would like to address two short points about my positionality. The first point is I do not identify as a conventional LGBT plus activist. I mean someone involved with organizations and actively participating in protest. The second point, which is more important, is about the book itself. The book is not written from a theological perspective, meaning that I do not approach the topic as a believer aiming to reconcile Islam and homosexuality. So reading it through a theological lens would be inaccurate. That being said, I strongly, of course, support LGBTQI plus individuals and activists, and I hope my research contribute to their cause from a critical, non-theological perspective. Okay, let me begin with this question, which might be your question as well. Why was this study demanded? Why was it needed? It's a legitimate question. There are several studies explored homosexuality in Islamic context from cultural, social, and historical aspects. Also, in the last few decades, Sunni scholars presented alternative legal and theological interpretations for homosexuality in Islam. So why another study? In contrast to Sunni scholarship, Shi'i scholars have often refrained from engaging in this debate. And this silence is particularly notable given the fact that discussions of modern gender and sexuality in Imami tradition somewhat began with Ayatollah Khomeini's fatwa legalizing gender confirmation surgery for transgender individuals in the mid-20th century. So the urgency of the study is evident, as there was a lacuna that I wanted to address, so to enrich the existing scholarship on sexual diversity in Islam by doing this project. So I mentioned that Khomeini's fatwa on the permissibility of gender confirmation surgery as GCS, which was issued in the 1960s, in my view marked a real turning point for these debates within the Shi'i legal tradition. Okay, let me see. Yes, this time I succeeded. Wow. So you can see the fatwa here. Unlike what some scholars and studies suggest, I argue that the emergence of this fatwa wasn't about political agendas to heteronormalize homosexual individuals or to cure a perceived deformity. Yes, later, post-revolutionary legal and medical authorities might have framed it this way, but at the time the fatwa was issued, that wasn't the case. To fully understand the impact of Khomeini's fatwa, we need to consider the timing. Remember, that was in the 1960s, well before the 1979 revolution. Neither Khomeini nor his political rival at the time could have predicted that such a tremendous shift in Iranian politics would happen, much less that Khomeini himself would be end up as the supreme leader, carrying both religious and state authority. However, what makes the fatwa especially significant is that it was issued in a period where many theologians, whether Christian or Jewish or Muslims, believed that it was impermissible for transgender people to undergo gender confirmation surgery. This is still a common position among Sunni legal schools and many Christian theologians. They believe that GCS is a violation of God's creation and cannot be altered. So the question arises, how could such a fatwa even be possible? What legal principles did Khomeini draw on to issue such a ruling despite objections to GCS? In other words, what kind of discursive spaces existed within the Iranian legal framework that enabled Khomeini to drive a position so distinct from those of most Shi'i and Sunni scholars of his time? It is interesting to note that many earlier studies neglected these critical questions, and instead of asking how and what, they inquired about why this fatwa. So then they started to speculate about Khomeini's motives and often misunderstood the actual formulation of his legal decision. In some of my publications, I try to explore the legal hermeneutical reasoning behind this fatwa, trying to understand precisely which principles Khomeini relied on to justify the fatwa. It demonstrated that the fatwa wasn't meant as an obligation for transgender individuals, nor was it grounded in a medical framework. In fact, the medicalization of transgender people was irrelevant to this ruling. As I delve into Khomeini's ijtihadic methodology, this question emerged. Can't we or couldn't we use this same approach to examine homosexuality within Islamic legal tradition? Which eventually led me to pursue this line of research further. So my primary objective in this study was to address this question: what are the discursive spaces concerning homosexuality in contemporary or modern Shi'i legal scholarship? The study the book made some contribution to the scholarship, such as, to my knowledge, the book is the first comprehensive academic examination of homosexuality in Shi'i context. And theoretically, it goes beyond essentialist and social constructionist framework. Something that previous scholars such as Scott Kugel, for example, asserted that Islam and homosexuality can coexist only if one believes that homosexuality is a dispositional or an inborn desire or orientation. But most importantly, the methodology I used represents a contribution that extends beyond this specific topic, which means the work does not rely on modern hermeneutics, scientific postulations, or liberation theology. And instead, it employs a domestic methodology rooted in Shi'i ijtihad. So you might ask, why? I have, in fact, gone into detail in the introduction to the book about why I chose not to follow the more familiar methods often used by scholars in this field, like modern epistemology, modern hermeneutics, or feminist critical theory. So I won't repeat all that here. What I do want to add, though, is something I didn't mention in the book. On one hand, in the modern Shi'i legal context, you barely come across discussions about homosexuality as we understand it today. Instead, the focus is typically on two other categories called livat and sihaq or musahaqa, which refer to some kinds of pre-homosexual same-sex sexual practices. And unfortunately, these jurists haven't been properly educated about modern homosexuality, and in the Persian context and environment, they're still using the offensive terms hamjinsbazi instead of hamjinsgarai. The former with the suffix of bazi contains or connotes a negative and insulting connotation, while hamjinsgarai refers to a group of people who choose a specific lifestyle. So this is, on the one hand, we see that we don't have direct discussion on homosexuality in legal texts. And on the other hand, my goal was to find spaces in legal tradition that could be used to advance scholarly conversations on homosexuality in Shi'i law. In other words, I wanted to study texts that didn't directly address my topic. So I needed to find a way to make those texts speak to these discussions. So I thought the best way to do it was to use the same methodology that traditional jurists or so-called ulama use to derive legal rulings on any novel matters, and that is the methodology of ijtihad. But then, as you may see, the experimental nature of this study comes through here. Imagine me here conducting research in a modern Western academic setting while using a methodology rooted in traditional Muslim scholarship. Yes, I'm humbly aware of the risks involved in this approach. This is why I invite scholars to critically engage with the work and assessing how feasible this method is when applied to modern topic. But what is highly important to note that I am not practicing ijtihad here to issue a fatwa on this subject. As I've mentioned several times in the book as well, this book isn't meant to serve as a guide for finding solutions to legal issues, or if you wish, to issue fatwas. That's the job of, in fact, jurists, mujtahids, marja, muftis. And I don't feel brave enough to put myself in their shoes. So, my intention was to use the same methodology to highlight the existing discursive spaces that could spark constructive dialogues between reformist and traditionalist Muslim, encouraging them to re-examine this topic. So now the question is, okay, what is modern paradigm of Shi'i ijtihad that you're talking about and you're going to deploy to do your research on homosexuality? And unfortunately, there is not much available on modern Shi'i ijtihad and modern legal theory as well, usul al-fiqh, in Western scholarship. Significant studies are practically absent. Aside from a translation of an introductory book by Muhammad Baqir al-Sadr done by the late Professor Roy Muttahida, however, this choice is puzzling, as even in Shi'i seminaries of Qom and Najaf, for example, this book is not a commonly cited text. In addition, it's a very elementary step to in the field of legal theory. So this translation, despite the fact that I must admit it's been done brilliantly, I believe doesn't give readers a clear picture of modern Shi'i legal theory, let alone Shi'i ijtihad. So this is why I felt it was necessary to include a chapter that briefly explained modern Shi'i ijtihad as a methodology, and this chapter provides a straightforward first-hand insight into the essential basics of this methodology, useful for both students and scholars interested in Islamic law. So this paradigm of Imami Ijtihad was established by Al-Wahid al-Bihbahani and his immediate students in the 18th century, following their defeat of the Shi'i scripturalist so-called Akhbari school. However, this concept of ijtihad only was carefully articulated and widely accepted a few decades later, thanks to the efforts of Al-Sheikh Murtaza al-Ansari, who died in 1864. According to al-Ansari, as you can see on this slide, ijtihad is a method by which jurists can definitively attain or justifiably derive legal rulings from reliable sources. So in contrast to other definitions of ijtihad, like ijtihad as a personal opinion, al-ijtihad bil-ra'i, maybe you've heard this more, or legal analogy qiyas, which is very common and prevalent in Sunni context, or uncertain decision, al-ijtihad al-dhanni, which is common again in Sunni context, and it became prevalent in Shi'i context from I think it was like from the 13th century by Al-Muhaqqiq Al-Hilli and Al-Allama Al-Hilli until the scripturalist school, which they, of course, defeated and challenged this notion of ijtihad in Imami context. In this chapter, there are also debates regarding the assumptions underlying ijtihad as well as its prerequisites and qualifications, which I skip here, and you can read it yourself. But what is highly important to mention today is about the process of ijtihad. And here you have an oversimplified version of the process of ijtihad. When they say we do ijtihad, it means something like this. It's a really simplified version. It doesn't project the nuances that this process can take. But it works for us today. So according to this process of ijtihad, you have 2 points. One, subject, as they call it, mawdu'at, means subject, issues, phenomena, if you wish, challenges, issues, something that you face or encounter, and then you want to know its legal ruling in Islam, which driving the legal rulings is the second step. So, according to this process, the first step is jurists are required to have a complete understanding of the subjects, topics, phenomena, mawdu'at, of their studies, so they can derive relevant legal rulings. However, it is commonly accepted that a mujtahid does not need to always initiate an independent investigation of the meaning and identification of the subjects of legal rulings in all cases of ijtihad. This is why jurists generally list 3 types of subjects. Here you can see. So the first type is subjects which are created, defined, or determined by the scriptural text, the Quran and Hadith, which are called divinely created subjects. Such as, most of the devotional, if not all devotional subjects, like prayer, salat, fasting, so, etc. Okay, these are the first type. And the second type is subjects that are determined by society, whether the general public or the professional community. These subjects are called customary subjects, al-mawdu'at al-urfiyya, such as topics relating to human social interactions, mu'amalat, they call it in Arabic, including commercial transactions. And the third type is the subjects that were originally customary, but their scope was explained or expanded or limited by the Quran or Sunnah. such as the definition of marriage. Normally they provide this example, and they claim that the meaning of pre-Islamic marriage in pre-Islamic Arabia was much broader than it was in Islam. And based on Shi'i ijtihad, the first and third types of subjects, meaning that the divinely created subject, or I wrote here, Shi'i created subject, and originally customary but expanded or limited by the revelations, these two groups, these two types, a mujtahid needs to conduct an independent investigation. However, regarding the customary subject, mujtahids are not required to independently investigate them, but they may acquire knowledge about such topics, for example, gambling, usury, and different types of commercial transaction, by consulting the general public. Alternatively, they may consult experts with specialized knowledge about, for example, different types of insurance and the use of medical technology to facilitate procreation. So, after a mujtahid learned about the meaning of its research, the subject, the phenomenon, then the second step is to investigate Islamic sources of proofs as well as general principles to drive a legal ruling. The nature of these sources and principles are discussed in the field of usul al-fiqh, legal theory. Therefore, modern Imami jurists often consider usul al-fiqh to be the most significant tool of ijtihad. According to al-Khurasani, usul al-fiqh is knowledge of the prepared rules in order to drive divine legal rulings. It is a skill or profession, sana'ah, on which one would recognize the rules that might be employed in the process of driving legal rulings, or that might be terminated to legal rulings in practice. So this conceptualization of usul al-fiqh, driving from a post-akhbari understanding of legal theory, was firmly articulated by the school of al-Shaykh al-Ansari, as I mentioned. And ever since, Imami ijtihad has been conducted on two levels. And that is highly important to be aware of, because it's still in the Western scholarship, Imami ijtihad has been considered as one level process, the same as Sunni ijtihad. And that is not accurate. So ever since, there are two levels. Ijtihad has two levels. It's been conducted on two levels. On the first level, a jurist should explore actual divine legal rulings, which they call it al-ahkam al-shar'iyyah al-waqi'iyyah, through the primary sources of argumentation called ijtihadic proofs, adilla ijtihadiyya, which are these adilla ijtihadiyya are the Quran, Sunnah or tradition of Muhammad, and in the Shi'i context, and the 12 Imams, and Muhammad's daughter Fatima as well. Aql, reason, and ijma, consensus, though ijma is highly contested in Shi'i context. If a legal ruling cannot be derived this way, then the jurist should apply the second level of ijtihad, tackling the issue through general principles called juristic proofs, adilla faqahatiyya. This level of ijtihad does not evoke actual legal ruling, but results in apparent divine legal ruling in practice, al-ahkam al-shar'iyyah, al-zahiriyyah, and al-amaliyah, which is, it doesn't even aim to discover an actual legal ruling. It's just to solve your problem in practice. Based on these two levels of legal reasoning, Al-Ansari proposed an epistemological taxonomy concerning different degrees of knowledge that the principles of legal theory might ultimately provide. Following this taxonomy, there are three types of proofs in modern Shi'i legal theories. As you can see here on this slide, the first type is definitive proof, dalil qat'i, a proof that leads to certainty in a legal ruling on a given case. This type is based on evidently clear text, nusus of the Quran and Sunnah, Khabar mutawatir, which is a hadith, a khabar transmitted through multiple chains. And reason, if it's provide certainty. The second type is called uncertain proof, adillah or dalil dhanni or amara. It's a proof that leads to an uncertain opinion in a legal ruling. The apparent meaning of text, zawahir of the Quran, and Sunnah, khabar wahid, which is a hadith transmitted through one chain, and indecisive reason are regarded as uncertain ways of reasoning. And finally, the third type of proof called usul amaliya, procedural principles, which can be applied when the legal ruling on a given case is doubtful, ma'al shak, after you mujtahid exhausted themselves to drive a legal ruling on a topic at the first stage or the first level, but they couldn't do that. They couldn't make any conclusion, then moves to the second level, and here, in fact, he has doubt. He's not sure that what the legal ruling on this topic, a specific topic, is, so he moves to the second level and applies some principle to solve the problem in practice. So, according to Al-Ansari, the first type of proof results in actual divine legal ruling, whereas the second and third types of proofs may result in apparent divine legal rulings. However, apparent legal rulings provided by the second type of proofs, namely amarat, are different from apparent legal rulings based on the third type, al-usul al-amaliyya, because the former type leans towards actual legal rulings, although through uncertain opinions. So it cannot decisively determine the legal ruling, but still, it tries to discover or uncover the actual legal ruling. However, the third type, usul amaliyya, never aims to or results in actual legal ruling, but merely provides grounds from which to solve legal challenges in practice. So therefore, modern jurists categorize the legal rulings derived from such principle, as I mentioned, apparent divine legal ruling in practice. So now let me go back to the previous slide about the process of ijtihad. And, based on this process, now let's assume that a jurist or a mujtahid encounters a subject or a phenomenon called homosexuality. And then he wonders whether it is permissible or prohibited in Islam. How should this jurist understand the Islamic stance on homosexuality applied ijtihad? So to answer this question, let's examine how modern paradigm of Shi'i ijtihad approaches this question. As I just elaborated, ijtihad starts by determining to which of the three categories of mawdu'at, namely subjects, homosexuality belongs. Is it a divinely created subject, or originally customary but shaped by the scripture, or no, purely a customary subject? So I designated a chapter to elaborate on the concept of homosexuality, chapter 3 of the book, and there I extensively discuss homosexuality as a modern phenomenon, which often is often articulated as an egalitarian way. I have to go further here. Yeah, correct. Which is articulated as an egalitarian way of life between same-sex peers who identify as gay or lesbian with a shared sense of sexuality that presumes sameness and mutuality in terms of social status, sexual desire, and choice of partners. Such a category is neither based on power relations, nor on hierarchy in gender, sexual rule, or age differences. Thus, it may categorically happen between two adults, two men or two women, who have a mutual sexual attraction to same-sex mates choose to consensually practice same-sex sexual relationships and identify themselves as homosexual men or women. Building on this identification, I then followed David Halperin's lead by using a genealogical approach to trace various pre-homosexual behaviors and then compare them with homosexuality. I could trace 7 pre-homosexual behaviors, and then I compared them with homosexuality, and there I showed that none of those categories align with the modern concept of homosexuality, which means this phenomenon didn't exist in pre-modern Muslim culture. A quick review of the Quran and Hadith, or Sunnah, reveals that homosexuality as understood today does not appear in these primary texts. While certain same-sex sexual behaviors are mentioned in the Islamic scriptures, they do not equate to homosexuality in its modern sense. So, juristically speaking, homosexuality shouldn't be considered should be considered as a customary subject. Rooted in social and cultural context rather than directly regulated in Islamic text. Now, with a solid understanding of homosexuality, the next step, or the next logical step, would be to consider the legal ruling on this phenomenon. And I explained that deriving a legal ruling on any subject is a two-step process, right? The first step is to examine through the topic through the ijtihadic proofs, adilla ijtihadiyya, including the Quran, Hadith, reason, and consensus. And if we cannot derive the legal ruling at this level, at this stage, then we move on to the second level and try to examine the topic through juristic proofs called procedural principles. Okay. So in the book, I, convened 3 chapters, chapter 4, 5, and 6, to delve into the ijtihadic proofs, focusing closely on what these sources offer on homosexuality. And in this chapter, I apply the legal, hermeneutical, and hadith-based, as well as rational frameworks used by contemporary Shi'i jurists. So I intentionally avoid modern interpretive tools. Had I employed modern hermeneutics or liberation theology in examining the Quranic accounts of the people of Lot, for example, or verses on indecency of males and females, or had I used modern critical hadith methodology advocated by a scholar like Joseph Schacht, Wansborough, or Joinbull for examining hadith on same-sex sexual behavior, my task would have been far easier. So you will recognize by reading the book the complexities and nuances of my discussion surrounding the Quran and Hadith on homosexuality. The research finally resulted in the fact that at this stage, driving an actual legal ruling on homosexuality remains challenging. And since Shi'i ijtihad does not validate legal analogy, qiyas, any attempt to equate homosexuality directly with pre-homosexual behaviors, such as these 2 categories, or the other 7 categories that I discussed in chapter 3 of the book, like livat and sihaq, has not probative force or hujjiyah. So it wouldn't be, because qiyas doesn't have any hujjiyah, is not validated by Shi'i legal tradition. Therefore, the ijtihadic approach directs us to a second practical level of reasoning. And chapter 7 in the book, in fact, aims to explore this level. And here I examine various procedural principles, such as the priority of divine exemption, they call it asala bara al-shar'iyya, or the priority of divine precaution, asalatul ihtiyat al-shar'i, that jurists might or could employ to address this phenomenon, which potentially supports a permissible view of homosexuality in Islamic practice. Not as an actual, of course, legal ruling, but as a functional ruling in light of contemporary circumstances. This detailed exploration into Islamic procedural law might open a possible path for accommodating homosexuality within Islamic practice today. So, I don't know how much time do I have. 9 minutes. Okay, good. I think I'll be finishing. Can manage to finish within 9 minutes. So to conclude, let me summarize the key discursive spaces for essential frameworks within, or essential frameworks within the modern paradigm of Shi'i ijtihad. These frameworks can be utilized to interpret any emerging phenomena or subject and to offer a clearer understanding of a potential Islamic stance on these matters. I identified 4 essential discursive spaces within modern Shi'i ijtihad that can be used in contemporary debate, which I only covered 2 of them in today's talk. The first one is considering modern Shi'i ijtihad as methodology. So I talked about it enough, and I mean, there are details and nuances on this topic that you need to go by yourself and read and get yourself familiar with the topic. But then also I want to add now, just think about the experience Iran faced after the massive political turmoil and change by a revolution led by Khomeini and his ijtihadic doctrine of Wilayat al-Faqih, the governance or guardianship of the jurist, and its ramification, and the case of Iraq after the collapse of Saddam Hussein's regime following the US-led invasion of the country in 2003. And ever since, the Shi'i majority country of Iraq has been experimenting with a new religio-democratic transformation in which Ayatollah Ali Sistani, as the most influential religious figure, is playing a crucial role in the development and deployment of this new system. Overruling the doctrine of Wilayat al-Faqih, Sistani in his practice of ijtihad holds that jurists are not entitled to independently establish a political system during the occultation ghaibah of the 12th Imam. Rather, they may provide general guidance or advice to people and the government in power. So also the vital role of Shi'i ijtihad can also be acknowledged in the reformation and modifications proposed by jurists on various topics and cultural issues, including the fatwas on topics concerning gender confirmation surgery that we just discussed, marriage equality, sperm donation technology for the purpose of procreation, music, etc. This is one discursive space that anyone who's going to talk about sensitive topics such as homosexuality, intersexuality, transgenderism needs to be aware of. The second discursive space is the procedural principles as practical solutions, which we covered again today. As I mentioned, in modern Shi'i usul al-fiqh, legal reasoning is divided into 2 fundamentally different types of proof. Ijtihadic proof, which may result in actual legal rulings, and juristic proofs, which consist of rules that do not serve as the basis for actual legal ruling, but only guide jurists in tackling a given issue in practice. Although juristic proofs were established in Shi'i legal theory much later than Adilla Ijtihadiyya, it is striking that both carry equal weight in recent Imami Ijtihad. Jurists have come to realize that an increasing number of complex modern topics need to be explored through an Islamic lens. However, no scriptural text from the Quran or Sunnah can be applied to most of these topics. Moreover, many such cases are not subject to reason or rational proof. As a result, these principles of the second level of ijtihad are highly constructive in providing guidance or solutions for Muslims to manage matters concerning their daily lives. And then there are two other points, use of legal maxims and the rule of time and place in ijtihad, two other discursive spaces that I did not talk today. Let me just conclude my talk by mentioning that my objective in this book was neither, cannot emphasize enough that my aim was neither to decisively present a conclusive view on homosexuality in Imami law, nor to assert an inclusive ijtihad to derive a legal ruling on homosexuality as a mujtahid or a mufti would be expected to do. Instead, I aim to identify potential discursive spaces in modern Shi'i ijtihad and to examine how this paradigm can potentially use its repertoires to engage with this topic. The controversies consulted in this study, I hold, can enhance traditional jurists' awareness of this timely topic. Inspired by the present work, I hope that Shi'i jurists can move on from traditional legal stances on the pre-homosexual categories of livat and sihaq and instead revisit the topic of homosexuality independently. By applying modern ijtihadic rules and potential discursive spaces, they could rectify the existing punitive regulation in Imami law on homosexuality. By and large, I urge both traditional ulama and Muslim reformists not to disregard or devalue such potential spaces in dealing with modern topics. Instead, they should hold constructive dialogue, as I mentioned, with one another to open new vistas in negotiating modern topics concerning sexuality and gender equality, including intersex topics, transgenderism, pansexuality, and in a wider context and sense, those who identify as queer. Thank you very much, and I need to stop here. Yeah.
Thank you, Professor Alipour, for that very fascinating talk. A lot of rich material in that presentation that I think we were all trying to digest. I would like to open up the floor to questions.
Thank you so much for your talk. I have 3 questions, if I may. 2 of them should be quick questions. One, you mentioned the conceptualization of homosexuality as an egalitarian way of life. If you could expand upon that, I don't think I understood what you meant by egalitarian. Is this an Islamic legal definition? And does egalitarian refer to mutual attraction between same sexes? 2, what happens after ijtihad? Does there need to be collective agreement between multiple mujtahids for the ruling to be somewhat accepted or established? 3, are there discursive, you mentioned discursive legal spaces for homosexuality, that's what you were exploring in your talk. Are discursive legal spaces for homosexuality any different than discursive legal spaces for any other topics? Because if not, then what makes it if it's different than any other topic specifically? Thank you.
Okay. Thank you very much. 3 good questions. The first one, No, that is a definition that we understand homosexuality nowadays, because homosexuality is a modern concept. This is why I explained that in Ishahadic process, they have subject, and they say there are three types of subject. Subjects that God, the lawgiver, already explained. So these are the subjects that we cannot intervene, right? So it's the mujtahid's task to understand and also elaborate on it and go for its legal ruling. The second topics are customary, but God or the lawgiver initiated to expanded or limited the meaning of the subject, right? And these subjects as well, we cannot intervene. But there is another type of subject, which is customary subject. So anytime a phenomenon, a topic, a challenge, an issue appears, okay, so as a Muslim, you want to know what is your stance towards this phenomenon, meaning that what Islam says about this. Is it permissible to practice upon this matter or not? So if the subject is a customary subject, you need to understand the meaning of such subject by going to the society, by asking the society, whether the general public or the specialized society, and understand what they mean by this issue. And then, with that knowledge of the meaning, you go to the original sources and see what God might have said about that topic, its legal ruling. So homosexuality is one of such topic, meaning that it's a customary topic, so it's not the mujtahid who has to go and convene an independent research about the topic. No, the mujtahid only, to understand its legal ruling, needs to go to the society and see how the public understand homosexuality. This is a new phenomenon, and what we understand from homosexuality is an egalitarian lifestyle between two adult males or females based on consensual same-sex sexual relationships. So now we understand this meaning, and now, so the second step is how we can determine its legal ruling. Then two levels of ijtihad applies here. So you go first through ijtihadic proof, if the Quran and then Hadith, Sunnah, or reason says anything about the legal ruling on this specific topic of homosexuality. If not, then you move on to the second level and try to find a principle, a practical principle which can solve this problem. So, does it make sense?
No, I asked if there needs to be collective agreement.
No, that was another question. I just wanted to answer the first question.
Okay, no,
yeah. But the second question about, no, it's not. I mean, in Shi'i context, if you're a follower, so you need to see what your marja or mujtahid says about a topic. You don't need to see if all of them say something or the majority say something. Yeah. But you also asked.
The third question, you mentioned are discursive legal spaces for homosexuality any different than discursive legal spaces for other topics?
What do you mean other topics?
Because the point of the talk was to get to how and why mujtahids come to a decision, a legal ruling on homosexuality, and you went through the different legal steps of ijtihad. Is that any different than other topics that they are trying to
solve
a legal ruling on?
No difference. It's the same. It's a methodology that can be used. What I try to, in fact, bring to the scholarship was to say, okay, this is the way in which modern Shi'i paradigm of ijtihad works, and these are the discursive spaces, existing discursive spaces that can be utilized to answer sensitive topics such as homosexuality, transgenderism, and intersexuality, for example.
If that's the case, then does that not make the question of why more important than the how? If the legal
no, when you ask why, then you're going to go into the motivation, personal, individual motivations of a person who issued a fatwa. But when you ask how and what, then you're going to see the mechanism, the way in which they work on a topic and try to come to a conclusion. Yeah.
Sorry.
Yeah, exactly. No, that makes sense. Yeah.
Thank you so much. I didn't like how you sort of excluded Levot and Mossavar from the discussion and decided to treat them as two very different subject matters, given the fact that these are like the most direct existing rules in Sharia.
Yeah, very good.
What would be your solution to that?
Yeah, I mean, it's a very long debate. So chapter 3 really, chapter 3 is the gateway to read the book, and that is about the conceptualization of homosexuality. And there I try to explain, I mean, it was a long discussion to see how and to what extent homosexuality is distinct from other pre-homosexual categories. And in fact, Levot and Shiʿi are not among those 7 categories. I mean, the way in which jurists understand. Of course, Levot exists, but the meaning of Levot in in early Islamic Arabia has a specific meaning, which means sexual relationship between an adult man with a junior or with a very young boy. But anyway, what is important is jurists only consider Levot and Shiʿi as 2 same-sex sexual practice, 2 in fact behavioral practices. They don't care about the agent of the act. They don't care about if it was done mutually, consensually, and it was not based on power relation, and so on and so forth. While homosexuality consider all of these elements. And then your question might be, so what? As some scholars, of course, ask that. Doesn't matter at the end of the day. In homosexuality, there is also an act, right? Otherwise, homosexuals should be crazy. Why they have to suffer that much and then without having any kind of, act upon their orientation? Yes, and that is the point. Here, then when you dive into hadith tradition, then you find the reason behind the hadith, that why the hadith convey that some of these same-sex sexual behaviors are prohibited or even punishable. There you find the differences. The differences exist there, however, overlooked by jurists.
Thank you so much. I actually had the exact same question as Marius here, which is how do you distinguish homosexuality and love? So thank you for that. So if I understood it, at the end of it, you're kind of saying that the hadith talks about these power relations, and if that doesn't exist, therefore one can argue that homosexuality can be part of the ijtihad discourse, right? I have a very small question then, and it's very small. Procedural principles, is that a translation?
I got this from Ruy Muttahida. Yeah, it's a very good translation, I believe.
A translation of what?
Al-Usul al-Amaliyya.
Okay,
yeah, procedural principle. Yeah.
Thank you.
Any other questions?
I'm just curious about the context of Khomeini's fatwa. What was the phrasing of the question? And if we know anything about their background.
Oh, great.
And the other part, reading the fatwa, I was curious about the gender category used here versus the sexual. Because what it seems to me, it's reinforcing heteronormativity rather than addressing homosexuality in any way.
Yeah.
Because the whole point is that you need to, reaffirm the gender of the person as either male or female.
Yeah.
And then the sexual act will be within the framework of marriage.
Yeah.
Rather than homosexuality.
Yeah. So the fatwa, Khomeini has 2 fatwas on this matter about transgenderism. One fatwa after the revolution in 1987, 6, 7 something, a few years before his death. That is in response to a question. A person called Maryam Khatun Mulkahara, who asked him to issue a fatwa about his case. Her case. Sorry, because of to respect her anyway. Her case, and then Khomeini issued that fatwa specifically for her. However, this fatwa that I displayed on that slide, that is a fatwa that's been issued in 1960s, and there was no question. It's a legal manual when jurists write, so he just hypothetically thought about it. But why? This is also a point that I said why. I didn't answer the question why, because really I was not really that interested in this question, because even I remember when I was working on the topic, some friends told me that maybe he had a child or a relative who was like a transgender person and he wanted to solve their problem. I don't know, and I really don't care. What was important to understand what was legal reasoning behind Khomeini's fatwa, and I wanted to explore that. And so what you are asking about the fatwa, of course the fatwa is not about sexuality at all. It's about gender issue. But I used that while analyzing this fatwa, doing research on this fatwa, I've learned that, okay, if Khomeini could issue a fatwa on transgenderism and gender affirmation surgery or confirmation surgery, why not using the same methodology, for other topics, including homosexuality? The same topic for the case of intersexuality and so on and so forth, right? So the fatwa has nothing to do with homosexuality, of course, yeah.
But does he make a difference between biological sex and social gender?
No, I don't think so. I mean, in his fatwa, it's a very short fatwa. I couldn't come to this because it's 1960s, and I mean Khomeini as a traditional jurist, I don't think he was aware of this modern debates on gender and sex at all. It's a very modern discourse, right?
Let's go. Okay. Thank you everyone for coming.
Thank you. Thank you.